what is the background to this agreement? The new EU-US Data Privacy Framework, or DPF, entered into force on the 10th of July 2023. It offers a streamlined mechanism for exports of personal data from the EU and wider EEA to the United States. Given the importance of cross-border data flows to the global economy, and in particular the importance of digitally enabled services between the EU and the US, many businesses will welcome this development. Legal context is that the EU General Data Protection Regulation restricts exports of personal data to countries regarded as providing an inadequate level of data protection. The European Commission's approval of the DPF means there is now an adequacy decision in place to allow personal data to be lawfully exported to US organisations that self-certify under the DPF. The DPF is the third attempt by the EU and the US to implement a mechanism for exports of personal data to the United States after the previous mechanism, the Privacy Shield, was invalidated by the Court of Justice of the European Union in 2020 in its landmark Schrems II decision. In its judgment, the CJEU had expressed concerns about the scope and proportionality of the US government surveillance activities and the level of recourse available to EU citizens to object to such activities. While other mechanisms continue to exist to allow lawful US data exports, such as standard contractual clauses and binding corporate rules, it's hoped that the new mechanism will ease the burden on businesses by offering a more streamlined, principles-based approach to US data transfers. What are the main aspects of the agreement? Similar to the previous Privacy Shield, the DPF will only allow the transfer of personal data to qualifying companies that have self-certified. For example, the company must publicly commit to compliance with the DPF principles issued by the US Department of Commerce, disclose privacy policies in line with those principles, have fully implemented the principles, and perform regular verification of its compliance. The principles themselves are based on, but are not identical to, core principles of the EU General Data Protection Regulation and relate to matters such as transparency, choice, accountability for onward transfers, data security and integrity, and purpose limitation. In certain cases, companies are required to cooperate with EU supervisory authorities, and in order to qualify, the company must also be subject to the investigation and enforcement powers of the Federal Trade Commission or the US Department of Transportation. In relation to the surveillance concerns expressed by the CJEU in its Schrems II decision, the US government has now implemented enhanced safeguards relating to its intelligence gathering activities, and new redress mechanisms are available for EU individuals. However, it remains to be seen if these safeguards will be sufficient to prevent the DPF from suffering the same fate as its predecessor. Max Schrems, who led the successful challenges to the previous two EU-US data transfer mechanisms, has already vowed to challenge the DPF.
US-based organisations that continue to self-certify their commitment to comply with the Privacy Shield framework principles must now comply with the DPF principles, including by updating their privacy policies by the 10th of October 2023, or they must withdraw in accordance with relevant procedures. For eligible US organisations that don't currently participate, the DPF programme website enables them to make initial self-certification submissions for the DPF programme. For eligible US organisations that don't currently participate, the DPF programme website enables them to make initial self-certification submissions for the DPF programme. The US organisation will then need to recertify itself on an annual basis. The US Department of Commerce will administer and monitor self-certified US organisations regarding compliance with the DPF requirements, including potentially via random spot checks. The Federal Trade Commission and the Department of Transportation will be responsible for potential enforcement action. The new EU-US DPF only addresses transfers of personal data from the EU and EEA to the US under EU law, and is not a valid transfer mechanism under UK law, which also restricts exports of personal data to countries not considered to have an adequate level of data protection. However, the UK government has separately agreed a UK extension to the DPF, which is expected to become applicable as a valid transfer mechanism under UK law on the 12th of October 2023. The UK extension will create a new mechanism to facilitate the transfer of personal data subject to the UK GDPR to eligible US companies that choose to participate in the UK extension to the EU-US DPF. The extension will operate by allowing US organisations that have self-certified to the EU-US DPF to also elect to self-certify under the UK extension, provided they complete certain mandatory requirements, such as by making additional UK-specific commitments within their public commitments and indicating that election on their self-certification. Exports of personal data could then take place as applicable to those self-certified US companies that appear on the applicable DPF programme list, without the need to implement additional transfer safeguards under the UK GDPR, provided all applicable confirmations have been given, such as the confirmation that they have signed up to the UK extension and, where relevant, that their commitments cover HR data. For the purposes of the UK extension, references in the DPF to the EU and EU bodies or individuals should be read as reference to their UK equivalents. UK organisations should be mindful of the need to update privacy policies and document their own processing activities as necessary to reflect any changes in how they transfer personal data to the US, and also follow the relevant detailed guidance and rules, including, for example, the need to identify certain sensitive data and undertake various checks. Organisations should also note that the EU-US DPF and the UK extension does not apply to certain journalistic data.